Rock and roll. Hey, we're live. I'm back. Yeah, you guys, I'm like that bad penny. You can't get rid of me that easy. Yeah, I'm having a little trouble with my lighting tonight, so we're just going to go with it anyway and make it work. Because I know there's somebody out there ready to start learning some stuff. So hang on, let me give myself a thumbs up because I know I'm going to like the show today. So somebody's watching. Who's here? You guys check in so I can take roll. So let's see what we got on the list today to talk about. So you guys, welcome to live stream Advocates for Justice Foreclosure Defense Paralegal Service. We are different and we prove it. My name's Coach Neighbors, and I approve this message. Hey, first off, I want to start out and thank you guys for your support. I reached my first 1,000 subscribers, I think Friday. So that is one of the two requirements that I have to host ads on my site and to qualify for the YouTube Partnership Program and host ads on my site, on my channel. So the next qualification is I need 4,000 hours of watch time, and that's coming right along. I think I have 3,100 hours, 3,100 hours. So got about 900 hours to go. I'm hoping maybe we can make it there by the end of the month or the beginning of next month. So that's pretty cool. And we've been working toward this goal for a minute now. Let me check and see here. So first off, I want to let you guys know I made some changes to the online course. I removed the restrictions so students can skip around in the curriculum. I had one student bring to my attention, you know, if you get in the course and you're facing an eviction process, then you're going to want to skip forward to that eviction process situation to get started. But you guys need to keep in mind, in order for you to be in the right place at the end, you have to know everything along the way in the beginning, even if you have to start at a certain position to protect to protect your property. So you're able to do that now. You don't have to go through the whole front half of the course if you're in the back, if you need something from the back half of the course. So you should be able to get around in that a lot easier. And I'm adding a chapter to the online course. We're going to add a chapter about stating a claim for relief. The main reason these attorney fools try and dismiss our stuff is failure to state a claim. So I done a little research on that, and I found some great resources, and I'm going to put I'm working on putting those together right now. So you guys who invested in the lawsuit package, you're going to need to make some changes to your document to add these things or amend it or whatever. But we're learning as we go. And that's the good thing about this program is we're learning as we go. Now, one of the things I wanted to talk about is the rules that you're following in court. And you need to make sure that the rules you're following are the rules of civil procedure and not the rules of and not the local rules of the court that, in my opinion, are put together to help move people through court faster. And anytime you're getting moved through court faster, you're getting hosed. So you need to keep that in mind. Let me check to make sure if anybody has any questions. I want to make sure that I can see them. Okay, no questions yet. So we're going to move on. So whenever you guys are challenging, whenever you guys are in court, whenever you guys are in court challenging these fools trying to take your property, okay, the main thing that you want to be discussing is the jurisdiction. Jurisdiction is the only thing that you want to be discussing. And what you will be doing is you'll be filing your civil claim for in federal court for the fraud. You'll be filing your civil claim in federal court for the fraud in the alleged mortgage loan that they're saying they gave you. You never want to go into court and defend what they said you did or didn't do. I wouldn't even answer to it. If you read the civil rules of procedure for answering, you'll find out that you can claim certain defenses before you have to answer. And challenging jurisdiction is one of them. They don't like to talk about that in the civil rules procedure, but that is one of them. Jurisdiction can be challenged at any time. And if you do a good job with the documents and stuff that we put together, they're going to have a hard time crawling off and underneath that when you stick that in their face. And so if people understand that when you are in our program and you go into court to defend your property, we're not going into court to defend what they said you didn't do, what they said you did or didn't do. And this is why I don't need to know everything that happened all the way back to 2009, because we're not going to be talking about any of that stuff. If you go into court in foreclosure court and you go into court arguing the banking system, you will be hosed. And the reason you'll be hosed is because people don't realize that there is a difference between the mortgage fraud and the foreclosure fraud. There's a huge difference. And this is probably the second or third biggest mistake that most people make. They tie the two together. Most people think the mortgage fraud people are responsible for the foreclosure, and that's not true. The mortgage fraud people, the bankers or whatever, or the attorney for the bankers or whatever you want to call them, they're responsible for the mortgage fraud. By the time it gets into foreclosure, the mortgage fraud people then made their money and step to the side. And what you have now are third-party debt collector attorneys attacking your property as a third-party debt collector, illegally attacking your property as a third-party debt collector. And people who don't figure that out end up last in line. They do. You're going to end up last in line if you don't figure that out. Because if you don't figure that out, when you file your lawsuit, you will not have the person that's responsible for the foreclosure against your property. There will be nowhere on the paper on your lawsuit anywhere to be found. And that will be the attorney. The attorney is the one that signs to start the foreclosure against your property. Check the documents if you don't think I'm on point here. Check your documents. You'll see the attorney is the only one that signed them. Nobody from the bank signs anything. As a matter of fact, I have people in our private Facebook page, Foreclosure Rescue. They have contacted the bank and harassed them. And the bank has told them, stop bugging us. You need to check with the attorneys. We don't have anything to do with the foreclosure. Yeah. People need to wake up. Now, if you're in court and you need to tell, if you're in court and like in a hearing and you're defending your property, you need to tell them what's in your documents, even if they laugh in your face. You need to tell them what's in your documents like you believe it and you know what you're talking about. And I would always reference my legal team said this, my legal team put these together or whatever. And even if you have to read notes from your phone or from a piece of paper or whatever, it's better to do that and get the stuff on the record that you need to defend your property. Now, these fools are not used to getting their asses kicked in court. So when you come to them with the stuff that you're learning here, they're going to play it off. They're going to play it off, and most of the time they're going to play it off, and then they'll continue the hearing, or for some reason, or they'll ask you if it's okay to continue the hearing. And anytime they ask you anything, it's always a no, because they're asking you because they're going to throw you under the bus. So you need to keep that in mind. So anytime they're asking you to continue the hearing, you know that they're stalling. And one of the things we're going to talk about today, we talked about in the radio show last week, is how to control the attorneys in the hearing. Now, when you get in a hearing with the attorneys, you want to speak up first. When the judge comes out and sits down, you want to step up and speak up first. Introduce yourself as a state citizen and let the court know that you're challenging the court's jurisdiction because the attorneys do not have a witness. And without a witness, the court does not have jurisdiction. As a state citizen, you're not subject to the statutory jurisdiction without an injured party. They must have an injured party. And if the attorneys don't have an injured party, it's a problem. Anytime the attorney opens their mouth, you should object, and you should keep doing that until the judge says they're going to hold you in contempt of court. Anytime the attorney opens their mouth, you should object. And when they get done laughing and they ask you why you're objecting, you need to tell them you're objecting because the attorney cannot testify. What the attorney's saying is third-party hearsay information because the attorney was not present at the time all of these things were taking place that they're trying to put on the table right now. So the attorney's testimony is considered hearsay, third-party information. Attorney cannot testify on behalf of a fake entity that's supposed to be there as posing as an injured party. Now, the judge is not going to be happy with you. And if the judge is not happy with you, you're doing a good job. That's the way that goes. You keep that in mind. If the judge ain't happy, you're doing a good job. Yeah, I love this part of my job. Now, if the judge starts acting grumpy or refuses to or continues to allow the attorney to provide testimony to the court, then what you need to do is let the court know, let the judge know that you'd like to have the attorney sworn in so you can cross-examine the attorney. You have the right to cross-examine anybody that's providing testimony in your hearing. Now, they're not going to want to do that. And I'll tell you why. Because if they swear the attorney in so the attorney can testify, then the attorney has become a part of the case and cannot litigate a case that the attorney is a witness in. And only the witness gets to testify. You see how you can twist that up and stick it right in their face. Yeah, I love my job. And if the judge allows the attorney to testify, or you can actually, that'd be something that I don't want to appeal. I know, drive them crazy, but if you're gonna be a pain in the butt, you need to step up. And then one goal is to stay in court. So you're gonna do whatever you need to do to stay in court and get stuff on the record that you need for your lawsuit. So the other thing too about the attorneys is, well, I got a question. So what is the attorney's number one job in court? That's my number one question. And the second question is, and you guys may have heard this one before, so I'm hoping that more people get it right. Who runs the show in court, the judge or the attorney? So you guys think about those questions for a second while I switch over to the other screen and see how many people are here. And then we'll come back and talk about the answer to those two questions, and then we'll move forward. Stephen Johnson, Hey, buddy. And Isa, what can we do about the upcoming evictions? Do you have documents for that? So, Isa, I guess that is your name, Isa, ISA. So, are you talking foreclosure evictions? And if you're talking foreclosure, then yes. Um, I have documents for that. Basically, what you want to do is attack the what you want to do is attack the foreclosure or the eviction process to stop it if the eviction hasn't happened yet. And if it has happened, you can challenge it with the jurisdictional challenge. So yeah, I have documents. You can go to my website, and I'll post a link to it. Now the documents are on sale this weekend. I put them on sale for people in the radio show, and I wanted to hook you guys up too. So if you want to see what the sale price is, you got to go over there and look at it. Because I can't say it. It's so low, I don't want to say it. Okay, hang on a second here. I'm pulling that up so I can. Okay, so this first link I'm going to post in the group is to my document website where I have the lawsuit packages. And there we go. That's my website where the lawsuit packages are. And I'm also going to post a link to my paralegal school, where my online course, where we launched our first online course. And that online course, I'm going to add a section to it on stating a claim. And that is going to make the documents really badass. The people who are already invested in the document, once I get it finished, I'm hoping to have it done tomorrow. When I get it finished, you guys can, I'll let you know in the Facebook page, and you can message me and I'll shoot you over a PDF, or excuse me, I'll shoot you over a Word document of the claim that we're stating. It's probably just going to be a couple of pages different that you will need to add to your lawsuit if you haven't filed it. If you have filed it, and eventually they're going to make you amend it. And when you amend it, you can be more clear on stating your claim. Now, this link is to the online course. And I like this program. It's called Quad Pay. I've used them a couple of times to buy things that were a little, like $400. I didn't want to pay all the money at once. These guys allow you to make like 4 different payments to pay off something that you're wanting to. It's pretty cool. And they just take the payments out like every 2 weeks or whatever time period you work out. So I just said she's talking about apartment foreclosure. Okay, so you're talking rental. No, my documents are more for foreclosures. If you're to apartment foreclosure, I didn't know they foreclose on apartments. Hmm. Yeah, we have documents for foreclosure evictions, basically challenging the foreclosure, not really. And then we have documents in the package to block the eviction process. So that's one of the things that we teach you guys how to do. Okay, let's get back on the program here. So the question that I asked, what's the attorney's number one job in court? So the attorney's number one job in court is to protect the judge. And that's why you have to go after the judge when the judge violates you. When the judge is obstructing the administration of justice, you have to go after the judge. And I've added their reconsideration package, their magistrate judge reconsideration package into both of the lawsuit packages. So in that package, and I'll show you a little later on. Well, actually, I can show you right now. We'll show you what's in that package. Let's see here. We need to go to do a screen share. Maybe I can do a screen share if I can figure it out. Well, okay, sorry, evictions. So you're talking about evictions, a rental situation with a landlord. My stuff is not for that. If that's what you're talking about, that's not going to work. I lost one of my windows. Hang on a second here. Okay, so I lost my window and I can't screen share right now. So I don't know what happened to the window. So I'll screen share with you guys on Monday. Looks like I lost my window that I was using for YouTube. So I can't do the screen share. So we're just going to, I don't know what happened to that window. So anyway, we're talking, the attorneys are the ones, the judge, the number one job, the attorney's number one job is protect the judge. And that's why in the end, when the judge is obstructing the administration of justice, when you file a claim against the judge, move to recuse the judge in the reconsideration package, you have the documents you need to for demand reconsideration. You have a document in there to recuse the judge for providing aid, for helping their attorneys, give the attorneys unfair advantage. And you also have a motion in there that is a notice of claim against the judge. And it's actually the claim. So you can take notice out of it and it'll be the actual claim. That's the way we roll. We like to let them know exactly what we're going to be doing. So that's going to be included in the package for everyone. So in the non-judicial package, there were 16. Now I think there's like 20 or 21 documents in there. But don't freak out when you open it up and look at them, because you only have to do one at a time. So the other question is, who runs the show in court, the judge or the attorney? And we talked about this a couple of times. It's the attorney. The attorneys run the show in court. As a matter of fact, the attorneys run the show before court, because by the time they have a hearing and you get to court, The attorney and the judge have already worked out what they're going to do with you. They've already decided how that's going to go. So harassing the attorney before a hearing and harassing the attorney all the time goes a long way. And I always tell people, what I do is I call the attorney, I'll make a script from the lawsuit package, like say the 4 things in there that I think it's on page 8 or 9 or something. It talks about the FR 1099. Those are the documents that you would actually be forcing them to provide as discovery to verify the true nature of the alleged loan. And I would make a script asking them for those things, call a 2-minute script where you can call and talk on, because, after the first time you call, they're going to send you to the voicemail. So after you get the voicemail, then you can call and harass them and just read your script into the phone, into their voicemail, and make them think that you got it, all this stuff. They don't have to know you're reading it. Those small things go a long ways, and attorneys don't want to have you in court. They don't want to, if they can't control you, they don't want to have you in hearing. So best thing you can do is let them know they're not going to be able to control you by calling and letting them know. And they're used to people just sitting down, giving up and getting scared. That's what they're used to. They're not used to people fighting back. Now, the jurisdictional challenge with an affidavit, I want to do a quick update on that document. That document people have been using to get their judicial foreclosures stalled off while they're filing their lawsuit in federal court. And then once you get the lawsuit filed in federal court, usually so far, no one's been able to answer on the well, 2 people answered, but not on the merits. And there are other 7 people, no one answered. So they're filing defaults and motion for summary judgment and everything. But part of the problem that we're having with the jurisdictional challenge with an affidavit is people are using it, but the homeowners have no idea how long the other side has to answer, and they're not taking advantage of it. You have to make sure that you don't allow them to turn your situation into their conventional program. In their conventional program, it's all set up. They structured it, and you don't have a chance in it. So what I'm saying is, when you file a jurisdictional challenge with an affidavit or any documents, you file any of my documents that you get from us, and they don't respond in the amount of time that they legally have to respond in, you need to be doing something about it. And I'm not saying wait till the judge tells them to respond, none of that stuff. The rules that you need to be following are the rules of civil procedure. And the civil procedure rules, I think most places is 14 days. You're going to need to check on your own to figure out how long they have to respond. And you need to check to figure out what you need to do if they fail to respond. And you need to have all that stuff ready. So the day they don't respond, you can go down there and stack your stuff up in their face. If you drag your feet and you don't get this done in the time frame that they have to respond, the judge will answer for them. And I'm thinking the judge thinks that you have no idea what the hell you're doing. So the judge is going to answer and just dismiss your stuff. And if that happens, then the judge is liable because the judge don't have jurisdiction to dismiss anything. But they get away with it all day long because nobody holds them accountable. Nobody holds the judge accountable. Everybody thinks the judge has qualified immunity. Dude, the judge has immunity if they're following the laws and acting within their jurisdiction, and they're not doing either one of those. And they have you in an administrative court. So you have no constitutional rights. Yep. So people need to understand the judge does not have immunity. And the judge is not acting within jurisdiction if they're answering for the attorneys, and attorneys don't get to do nothing except sit over there and let the judge handle it. So if you use the jurisdictional challenge with an affidavit, make sure you check with your state and you know how long they have to respond. You keep track of the days, and when that day is up, you need to have your stuff already ready to run down there and file in the record and stick in their face. That's what you need to do to keep control of the situation. You can't drag your feet and allow them to take over your program. And the jurisdictional, the judicial and the non-judicial lawsuit packages are on sale this weekend until Monday at noontime. And I'm not telling you how much they are because I can't say it. You need to go check it out for yourself. So that's all I got to talk about tonight. I just wanted to come on. I'm working on that. Oh, got a couple other people here tonight. MYX Capital. Good to see you standing there. Staying at it, guy. Thank you. Yeah, I'm on it 24/7 almost. So I really appreciate you guys coming and watching my stream and subscribing to my channel. It's pretty cool. I have met the first requirement, and I have 1,000 subscribers now. I think I have like 1,018 subscribers now. I need 4,000 hours of watch time. I think I have 3,100. So that watch time is coming, and when that happens, I'll be able to monetize my site and make a few bucks off of the ads. And when that happens, who knows? Maybe I'll leave the prices where they are now, or somewhere close. Floyd Harrell, very good price with better information inside. Thanks for the great deal. You're welcome, buddy. Yeah, we do what we do. And I love pissing off attorneys. So, yeah, people in California were pretty pissed off about the eliminate property tax lawsuit deal. They were not happy about that at all. But you guys can see that really broke me. My heart was really broke up about it. Anyway, that's all I got. You guys let me know in the comment section if there's something particular you'd like to hear, as long as it's connected to the non-conventional program. I'll be glad to look into it and do a little research on it. And I'll probably be back on here Monday or Tuesday. So Rock Solid Natural Health says, Guy, what happens to the second firm that comes in? So if the first firm book took off or disappeared, the way I do it is whoever signs is the one you want to be going after. That's kind of a good way that I look at it. Whoever signs, the one that's responsible for sticking it in your face, is the one that you want to come after. And if they list everybody and their mother and all of this stuff, and all of those things, all of those extra people don't matter because they've already made their money off of the deal. So, and that's why I don't add them to everybody. All that does is complicate your service and what you have to do down the road. So I just said, how can I speak with you personally? So you want to speak to me about the landlord tenant stuff? My documents don't really handle that too well. But I put a link to my website, and my email address is on there. You can send me an email if you like. Isa. So you mean another law firm? So Rock Solid Natural Health, you mean another law firm that's coming in to represent the one that you have listed as the number one defendant? Is that what you mean? It's hard to tell. I'm not sure exactly what you mean. So If there's a second lawyer, a firm that's coming in to defend the law firm that you have, I would add them to the lawsuit too. And then I would probably serve them with the sanction motion that's in the lawsuit. And I would also file to strike their notice of appearance. And the reason you're striking the notice of appearance is because the lawsuit was filed in the wrong court. An attorney is considered a foreign agent, and a foreign agent has to file in federal court. They can't, that would be like someone suing you from another country in state court or even another state, and that's not the way it goes down. So they do it illegally because no one checks it or does anything about it. So that's the deal. So who signed it? Who's dragging you in court right now? Whoever's dragging you in court should be the one that signed it. Rock Solid Natural Health. So I said, so are you in foreclosure, or you want to talk about the rental situation? So Rock Solid Natural Health, you said just about to go file. So the question is, if there are two firms before we file the jurisdiction challenge, there was one firm who filed it. There was one firm who filed what? The lawsuit against your house? The foreclosure. You're going to have to figure it out. The goal is to go after whoever it is that's in your face right now. Whoever it is that's making you have to go to court and defend your property, that's who you want to sue. Yeah, I don't have too many documents, I said, for rental situations. Do they have you in court? So if they left and somebody else is in your face, then somebody else's signature is on the thing to start everything, right? Then that's who you sue. You need to remember, the more people you add, the more complicated it's going to be for you. Now, you should, on the right hand side underneath the case number, when we have written on there, you reserve the right to amend, so you can add anybody later. It's easier to do that than have to respond to 14 people's stuff. Hey, Spanky D. Tell people to look up the case laws you put up. Now, they don't have to look them up, man. All they got to do is use them. So you want to go after whoever's in your face, whoever's responsible for you missing your sleep at night and worrying about this problem. And so you want to go after all the other people. I wouldn't worry about them. The idea is to force the one coward ass attorney to have to take the heat for everybody else. No, Rock Solid, follow the instructions, man. You need to add the attorney that's in your face now. It doesn't matter about who's done it before or who started it a while ago. That's what they want you to do. because now you get sidetracked and you're going after these other people that don't have nothing to do with it. And that's the number one problem people make. They go after people who don't have nothing to do with the foreclosure. If they got out of it and some other people took over, then that's who you need to focus on. It's pretty simple. It's it's if you follow the instructions will tell you to write the name of the law firm that's in your face, not all the people from the past. And there's a reason for that. So, Floyd Hell, title dispute, you can have a handle what rock solid is referring the chain of title. Now, what rock solid is talking about is an extra attorney. He wants to add 2 attorneys, the one who originally signed and the one who took over. You can do that. You do whatever you want, man. If you don't want to follow the program, then you can't. You want to go after whoever signed that's in your face right now. I mean, if you go after whoever signed the complaint, you're going to have 15 people on there, and we're not going after all of those people. That's a waste of your time. You need to go after, there's only one person that's dragging you in court right now. I have not seen a foreclosure where 2 or 3 attorneys were all on there that actually signed the document against your house. Now, if that document was toast and another attorney took over, then that's the one you're going to add. It is a simple question. If the attorney that took over is the one that's dragging you in court, then that's who you add. You don't need to add all those other people. But I'm not going to argue with you over it. I don't argue with people. I tell people what to do. What I'm suggesting is you add the attorney that took over that's dragging you in court now, and not the one that skated out the back door. But you can add them both if you want to, man. It's up to you. It's your stuff. I'm only the coach. The least amount of people, the better you are, the better off you are. And then what you end up doing is you let that one attorney be held responsible for everybody else. That's the best way to do it. And now these other people are going to be putting pressure on him. He's going to be whining about it, and you start creating a problem. And then people start jumping the ship. So there's a lot more to the program than just what meets the eye. Well, I've answered the question a couple of times, Rock Solid Natural Health, and there still seems to be a question that you think we should add the other attorney that signed. But the other attorney that signed is not in the way now. So the new attorney signed the new paperwork, right? So if the new attorney signed the new paperwork to go after the foreclosure after the old attorney left, then that's the attorney that I would use. It is simple. I like to keep it simple. The attorneys are the ones that make it complicated. You want to sue who's responsible to dragging you in court right now. That's what I would do. But it's up to you. I'm only the coach. So did the attorney that's dragging you in the court right now sign? If they didn't sign, they have to sign a notice of appearance. The notice of appearance is what they give to the court to let the court know they're taking over. And if they didn't sign notice of appearance, then you should move to have it dismissed. So if the other attorney signed, then that's who you go after. Whoever signed, that's in your face now, not who signed all along, in the past or whatever. That's what I would do. Make it easy for yourself. Well, if the new one came in and signed, if the new one signed in, then that's who you go after. It is simple. Everyone always tells me it's complicated, but it's not that complicated. It's pretty simple to me. So just go after who's in your face right now. And then they were replaced. You mean the other attorneys came on? And if the other attorneys came on, they had to sign a notice of appearance to let the court know they were the attorney now, because these attorneys are foreign agents and they can't go into court without signing a notice of appearance because of the fact they're a foreign agent. Okay, guys, anybody else have any questions? I'm going to get back to work with that other project so I can get the how to state a claim written up so we can make our whole program here a whole lot stronger. So I appreciate all the feedback and help that everyone's providing. And I will see you guys in a few days. Have a good rest of your weekend. Bye. Let me see. Go to the studio. In stream. Yay.